Okay, while he's regulating the lighting, I'll probably do the same thing Steve did, which is just give you a little bit of background on myself and how I got into the oil and gas industry, or representing the oil and gas industry. First of all, I'm a graduate of Albany Law School. I'm proud to be a graduate of the school. I spent most of my career representing industry on environmental issues, and when we've had an active oil and gas industry in New York State, I've been involved with the industry. It goes back to the question just before lunch on the Article 7 process at the Public Service Law. I was involved with the amendments to that to add in the provisions in Article 7 for dealing with gathering lines. More recently, New York State really got active in oil and gas issues at about the turn of the century. Up until then, most of the oil and gas drilling in New York State had been shallow gas well drilling in the western part of the state, a lot of sandstone development, the Medina sandstone, some Queenston development up in the Finger Lakes region, but it was mostly shallow, vertical well construction, and it wasn't very controversial. The Trenton Black River play came along around the turn of the century, and I know that sounds funny, doesn't it? Just happened. It sounds like it should be a long time ago. But what happened is the geologists came to realize that we had significant potential in this state for developing this formation. It's a very unique formation. It's in dolomitized limestone, which is like a bunch of geodes put together, and there's a lot of gas under pressure, and it's got confining situations called robins that hold the gas in place. And so the wells are very deep. They're drilled 10 to 12,000 feet deep, and they have 4,000 foot laterals, and they're stimulated with chemicals, mostly acids. But that was what was happening around the turn of the century. Now, what happened is because those wells were very prolific, one of the wells in New York State, and I think it was 2003 or 2004, was the largest producing natural gas well in the country for that year. That there was a lot of money at stake. And so we found that our compulsory integration laws, which regulate how landowners participate in that process, were somewhat antiquated, and they hadn't really filled in how that was going to work. So we went through an overhaul of the law in 2005. I was very actively involved with that overhaul of the environmental conservation law as it relates to well permitting, well spacing, and compulsory integration. And so I represented one of the industry participants in that process. Ironically, just to show you how new the shale development is, even though we overhauled the law in 2005, we didn't think about drilling shale with horizontal wells. Shales were put into the spacing law as 40-acre vertical wells, because at that point, even though it was starting to happen down in the Barnett, it was too new to realize it was going to come to New York. So we didn't consider high volume hydraulic fracturing with long horizontal segments and multiple wells in a common well pad. So we had to come back in 2008 and amend the law to allow for that. That's when controversy erupted, okay? When the environmental community woke up and said they do not like hydraulic fracturing. A number of people in this room were lobbying on that, and we ultimately got the bill passed, but it came at a price. It came at a price that with the governor's approval message on July 23rd, 2008, he said we're going to have an update to the generic environmental impact statement, which has led to the 4-year process that's still going on today. So in that process, our firm has represented industry. We've been involved in drafting comments on behalf of the industry, and we're also involved in a number of regulatory proceedings before the DEC dealing with the administration of the old law and the new law. So now let's talk about municipal home rule, to ban or not to ban. That's my cover slide, but actually I'm not going to answer that question. I mean, Steve has given you some suggested pointers on what to do, what not to do. This is a great policy debate, whether municipalities should have this authority. It's not my role to decide that policy debate. It's my role as an advocate for our clients to argue what the law provides now, and I'm sure it won't come as a surprise to many people in this room. It's been our position that the municipalities do not have any authority to regulate not only the actual natural gas drilling activities, what people call the how of natural gas drilling, but also the where. In other words, you can't regulate through zoning or through a municipal ban natural gas drilling, and how do we get there? Okay. All right, first of all, let me tell you about the cases. We represent the operator in the Dryden case, and we're co-counsel for the landowner in the Middlefield case. As Steve pointed out, both of those decisions at the lower court level have held that municipalities have the right to ban natural gas development entirely. As an industry lawyer and looking for test cases, we like these cases because they were pure bans. Okay, so it wasn't a question of a municipality following Steve's advice to say, well, just do this. If you're at this end of the spectrum, you might get away with it. This was the mother of all regulation. Thou shalt not do it at all in our community. Okay, so they made good test cases. And they also make good test cases because in one case we have an operator whose rights depend upon the oil and gas leases and the temporal rights that they acquire from a lease. And in the other case we have a landowner who has correlative rights. How many people here know what correlative rights are? Good, that's good. Most people haven't even heard of it. The correlative rights are the rights of landowners to get together to have the resource developed and produced for the benefit of the group. And that's essentially what operators do for landowners. And so that case represents a landowner who wants her oil and gas rights developed. We are very close to finalizing the briefs. We've got draft records. The attorneys for the other sides are commenting on those. We're anticipating filing the briefs and the records in the next several weeks. So obviously we're kind of neck deep in this issue right now. We're expecting there'll be several amicus filings in support of our position shortly after we file our briefs. There's usually about a 45-day time period for the respondents to file their briefs, so we're expecting that the municipalities will file their briefs probably around early December. We'll have a couple of weeks to file reply briefs, and then the case will get put on a term at the appellate division, probably the February term. They're usually pretty good about getting decisions out 6 to 8 weeks thereafter, so I'm predicting March, maybe April. I'm picking my birthday, March 15th. That just makes it fun. So that's
the Ides of March.
The Ides of March. It used to be tax day too. I'm going the wrong way here. All right, so let's talk about municipal home rule for a minute. It's 3 simple words. Let me just say it. Municipal home rule. Now, if you believe in the people who support the right of municipalities to regulate this, you think those 3 words are the be-all and end-all of this debate, and that municipal home rule is such an organic authority that it trumps everything, including the right of the state or the federal government to preempt that. As a matter of fact, I want to say it one more time. Municipal home rule. I was kind of expecting Judge Gabrielli to come down and tell me I just didn't understand it and get out of this room and go away, but he's not, because the law, as is set forth in this slide, is very well settled in this state, that even though municipalities have great authority under the municipal home rule doctrine, the state has the right to preempt that authority. Okay, so we have the Albany Area Builders Association case, and the quote there that it's a fundamental limitation on home rule powers. And I like this quote: the font of police powers of the state. The state is a greater authority. So if you look at what this means, it means that the state can preempt a municipality just like the federal government can preempt the state. And the Wombat Realty is really a great case to understand the scope of preemption, because that's the case that tested the Adirondack Park Agency Act. Okay, when the state came in and said, we have this jewel called the Adirondacks in the Adirondack Park, and we're going to create the APA, and we're going to have state zoning, which is very unusual in a land use context. And that was challenged, and it was found that, yes, the state had the authority to do that, and they could actually trump local authority. Now, there's a couple of different kinds of preemption, and this is true at the state level and at the federal level, although some people will argue that if, at the state level, if you have express preemption, you can't have implied preemption. We don't think that's the law. First of all, express preemption is the easiest way for a court to find preemption. If they find a statute says notwithstanding your municipal home rule law, you can't regulate this subject matter. That's something that we, the state, are going to regulate. The courts have to enforce that. The other two types of preemption that you can have are conflict preemption and field preemption. So what is conflict preemption? Conflict preemption is if whatever you do at the municipal level conflicts with what they're doing at the state level. Now, Steve gave a bunch of examples of things you can do. I don't think you can really do many of these under the preemption analysis that we see flowing from the statute that I'll talk about in a few minutes. One of the things you have to look for is where is there conflict? Well, for example, everybody who's followed the SGEIS process and the draft regulations knows that the state has gone way overboard, some would say, in terms of regulating the where of natural gas drilling. They've got, they're prohibiting drilling in certain watersheds. They've got all kinds of prohibitions over different types of aquifers, setbacks for different types of structures and other things. And reasonable setbacks are okay, but they've made it so stringent that it's going to be difficult for the industry to come in and lay out spacing units, find a well pad location that actually fits into that scheme, and then if the municipality comes in and says, you know, that's really good that you did that with the DEC, but our Euclidean planning tells us this should be over in the southwest corner of the town, it basically can create a conflict. So let's just talk about the mine land reclamation law. Why are we talking about that? I thought we were talking about the oil and gas law. The proponents who say that municipalities have the authority to ban natural gas drilling, they say that the oil and gas law is exactly like the supersedure or preemption provision that was decided by the Court of Appeals in Prue Run. And that, I think that was back in the 80s, if I recall correctly. But essentially, you had a provision, and this is the provision right here in front of you, that the Court of Appeals had to interpret as to whether or not the municipality in that case could zone mining activities and where they could occur. This wasn't a ban, this was a zoning attempt. And one thing I want you to note in this statute, and this is the whole statute, and nothing but the statute, if you're a proponent of municipal home rule law, you'll only quote up to the first semicolon. However, I like to focus on the second part of the statute, provided, however, that nothing in this article shall be construed to prevent any local government from enacting local zoning ordinances or any other local laws which impose stricter mine land reclamation standards or requirements than those found herein. So the Court of Appeals was faced with that and a zoning by a municipality, and they said, no, there's nothing wrong with that. Municipalities have the right to zone, because in fact that's what the statute says. And so the authority of the municipality to zone was upheld in that case. Now, I'm not going to go through these next three slides, just to tell you that the legislature came back after Prue Run and made it even clearer that municipalities have the right to zone hard and soft rock mining activities. And ultimately what happened is in the Granite Asphalt case, the Court of Appeals upheld a ban, okay? But again, we started out with a law that invited zoning by its very terms. We then amended the law to give municipalities even greater authority to regulate the subject matter and zone the subject matter, and that's why we got to a ban situation that was upheld by the courts. Now let's go back to the oil and gas solution mining law, and let me go back and talk about the two cases. Both judges found this provision similar to the mining law provision that I quoted a few minutes ago. In fact, Judge Serio went as far as saying that they're strikingly similar. Okay, so now let's just read it. I don't have a lot of text for you today. I just bring the law, and I think it's pretty clear on its face. The provisions of this article shall supersede all local laws or ordinances relating to the regulation of oil and gas solution mining industries. Well, first of all, that's different. It's talking about all local laws or ordinances. And what kind of ordinances do municipalities enact? Dog control ordinances? Yeah. Maybe landman control ordinances, as Steve suggests. But the biggest ordinance that municipalities, the most common ordinance that municipalities enact are zoning ordinances. So we think that word is very significant. And the opposition, our opponents, point to regulation. And they say that's a very limiting factor. That only limits the how, not the where, and that's what they point to. But then let's go on with the statute. But shall not supersede local government jurisdiction. Again, that's not found in the mine land use law, over local roads or the rights of local governments under real property tax law. So we think that the plain English reading of that is that you're done, you're out of it. No laws, no ordinances, except your jurisdiction. Jurisdiction is a very important legal term of art, is limited to two subject matters, roads and taxation, okay? And if you look at this language in the context of the legislative history of this provision, it becomes very clear what was happening, because what happened at the time was that municipalities had started regulating the oil and gas industry, and the DEC was not very strong. They didn't have much staffing, and there was really no taxation system in place for the oil and gas industry. So at the same time that this law was adopted, what they did was they enacted a comprehensive ad valorem real property tax system that gives all that revenue to the municipalities and the school districts. They also enacted a damages compensation system for the municipalities, but the big enchilada, so to speak, was to give the communities the power of taxation. Now, I can tell you that there have been many projections about the tax revenue from the Marcellus Shale. One only has to go look at some of the Trenton Black River wells that were very prolific over the last decade, and you'll see that where those drilling episodes were successful, the municipalities and the school districts did very well. You could literally have school districts that would be, tax-free based upon the revenue they would get from this system. We all expect that the state is going to tinker with that system. They're going to want to put a severance tax or something to get some state revenue. But you also have to understand that the taxation system that's in place now also includes revenue based upon the production of the well. That's the way it's set up. So where that's going to come out, we don't know. But again, to go back to the simple statutory provision, we don't think that this statute is similar at all to the mine land reclamation law pre-Fru Run. Here it is. I usually bring poster boards. I just didn't have time to go back to the office to get them. But again, we think these are very dissimilar provisions. So here's the program bill. And again, we argue with the proponents of home rule laws to what this means. But I think it's a very clear legislative determination, legislative support for the proposition that they have a comprehensive scheme in the state law, and that authority had to be reserved to the state. And local governments' diverse attempts to regulate the oil and gas industry serve to hamper those who seek to develop these resources and threaten the efficient development of these resources with statewide repercussions. Now, this was a 1981 statute. What happened in the 1970s? How many people remember waiting in gas lines back in the 70s and the energy crisis? Okay, well, we had just come through an energy crisis, and we were realizing that domestically we had to find as much domestic energy as we could, and so that's why you see this kind of language. You see other language that I'll get to in a minute. So it goes on to say, with adequate staffing and funding, and they did come up with a funding mechanism, that they'll be able to address these concerns and assure the efficient and safe development of these energy resources. So let's go back and look at some other aspects of state law. Again, I'm just basically bringing you quotes from legislative history or state law. This is the declared policy of New York State under existing law. This is nothing we're proposing. This is nothing the legislature is considering. It's already there. All right, so there's three things that the policy says. You have to prevent waste. All right, you have to provide for the operation and development of oil and gas properties in such manner that the greater ultimate recovery of gas may be had, and then you have to protect the correlative rights of owners. Now, this is not something unique to New York. This comes from the Model Oil and Gas Commission model, and it's very similar to what's in other states. But these three concepts of preventing waste, promoting the ultimate recovery, and protecting the correlative rights of landowners are certainly part of our policy. Waste means, and I think this definition is significant. Remember I said that the opponents say that this preemption provision only says that you can't regulate the how of drilling. You can't tell them what size drill rig or blowout preventer to use, but you can tell them where. Well, waste means the locating, spacing, drilling, etc., which causes a reduction in the quantity of oil and gas recoverable from a pool under prudent and proper operations. So what does all that mean? Well, it tells us two things. Location and spacing are where, not how. Okay, and if you also look at the environmental conservation law, and part of the provisions that were in the law and part of the provisions that we amended in 2005, we have very detailed requirements regarding statewide spacing for each type of unit. For large multiple well pad shale wells, it's up to 640 acres with the pad approximately centered in the unit. So the government very directly does regulate the location and spacing, i.e. the where. They tell you all your units have to abut each other or leave enough room for a new unit to be created. So we think that without even going outside of the four corners of the ECL, we quickly get over the argument that, that the law does not regulate the where. And then you've got the state energy policy, which talks about, and this is a 1978 statute, which is what makes it fascinating, that it calls for the promotion and prudent development and wise use of all indigenous state energy resources, including natural gas development and natural gas from Devonian shale. The Marcellus and the Utica are Devonian shales. And here we had the legislature back in 1978 actually speaking to the promotion of Devonian shale resources. I've actually gone back and researched that. There was a Department of Energy grant to go out and look at Devonian shales in New York. There were some wells drilled. I guess the geologists will tell you we've always known it's there. We've always known it had significant potential, but until the industry put together the concept of a long horizontal well with multi-stage hydraulic fracturing and hydraulic fracturing, we didn't have the secret of how to get it out of there. So, you know, that's the end of my presentation. We think we'll be successful in the appellate courts. We think the appellate courts will not be as influenced by all the local controversy. We expect that they'll be able to get through these arguments pretty quickly and see that there's nothing similar about the oil and gas solution mining law compared to what the Court of Appeals decided in Fru Run with the mine land use law. And we're optimistic that that will send us on our way to the New York Court of Appeals. Thank you very much.